Hello, I'm attorney Palmer Johnson. I specialize in family law with a particular focus on mothers and helping them navigate the legal proceedings that affect their families. In today's video, I'm going to talk about relocating to another state when there's a child custody order in place and what that looks like and what your obligations are. The statute for this is very clear and it lays out what your obligations are. And I think it's important that people are aware of this so they don't inadvertently fail to do it, because there can be adverse consequences to a party that moves with minor children without providing the proper notice and opportunity to object to the other party. Now, Title 43, Section 112.3 essentially says that you're obligated to notice the other party of your intention to relocate 60 days prior to relocating, or within 10 days of finding out that this is going to happen. It goes both ways to kind of account for a sudden change in job or opportunity that could cause someone to need to potentially relocate before or not know about it 60 days in advance. But that notification needs to be in writing. So it's not enough to just pick up the phone and call the other parent and tell them, I got a big promotion and we're going to be moving from Oklahoma to Dallas on, such and such date. That's not going to be sufficient. It's going to need to be in writing. It's going to need to include as much information as you possibly can share, including the address, the specific date of the move, a proposed new visitation schedule if that's necessary, because of distance. It's going to significantly change the circumstances. It also needs to include a warning to the other party that from once they receive this notice, they've got 30 days to object to it, or the relocation is going to be permitted. So the big things here that would prevent someone from a custodial parent from moving and relocating with the children would be showing that it's not being done in good faith, that it's the sole purpose is to alienate the other parent. There needs to be some strong underlying reason for why this move is happening, because it's going to affect the other parent and their rights and access to their child. And absent more extreme circumstances where there are a lot of safety issues or reasons why the other parent would have very limited visitation, you need to make sure that what you're doing is in good faith, and that you've disclosed to the other party really the real reason why you want to do that. So if you follow the statute and provide notice to the other side and they don't object, then you're in a very good spot to be able to move. What you don't want to do is just decide to move, not notice the other party, because you can actually end up getting punished a little bit by the court in that scenario. They can order the child back. The court can't tell you that you can't move, but they could potentially make a modification to the child custody arrangement, make a change to the visitation schedule. They could even order you to pay attorney's fees and cost associated with the legal proceedings if you were found to be the party at fault violating the statute. So it's not a difficult obligation to meet, and I think it's fairly reasonable, but it is a pitfall and something that when it comes up, most people haven't necessarily pondered. If you have a child custody order in place and intend to relocate and you need some additional advice about how that should be done, please reach out to me at moms.law, and I would be more than happy to assist you with the proper way to go about that process to ensure the best possible outcome for you and your family.